Principles of justice and the rule of law. The principles of justice and the rule of law apply all across the world. All nations that are signatory to the International Bill on Human Rights have come under this legal obligation. The ruling structure on earth is not individual government domestic laws, but the hierarchy structure of law that flows from the covenants and the international order. That is why we find this principle of justice articulated in the Vienna Convention Article 27. A party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. A party refers to the countries, to the nations that signed the International Bill on Human Rights. The rule of law states that the government cannot create laws and then try to enforce them on people if these laws violate the international order. What we are seeing is the principle of justice very clearly. Domestic law is not the highest authority on earth. Secondary witness. A secondary witness to this truth is evidenced in the ICCPR covenant itself. We can see the rule of law being brought forth clearly under Article 2 of the ICCPR 2.2-, where not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. We can clearly see that the governing authority, the governing power in operation, the governments of the countries must take the necessary steps to give effects to the rights. This clearly shows us and teaches us the hierarchy structure of law, a warning encoded in law. The third witness. Not only are the governments of the world under the obligations to follow the international order, universal order. The law itself gives a stern warning to those peoples who run the domestic governments, that their authority is completely governed by the covenants themselves, that no government has the legal right to act outside the confines of the covenant. ICCPR Article 5. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. The covenant is the controlling mechanism. It is the authority that governs all governmental actions. As we see in the above article of law, the actions of the governments are constricted, are confined by the covenant, not by arbitrary choice, not by political will or party will, but through and by the rule of law. All government actions are subjected. The fourth witness. Under the international order, all branches and operations of government fall under this hierarchy of law. This means court systems, members of the bar, government departments, municipal bodies, hospital and medical care, educational systems, and everything operating as a governance structure are governed by the rule of law. Under international law, all those departments of local governments, court systems, members of the bar, government departments, municipal bodies, hospital and medical care, educational systems, and all the people who work in those departments are considered organs of the state. Responsibility of states for internationally wrongful acts. 2001. Article 4. Conduct of organs of a state. 1. The conduct of any state organ shall be considered an act of that state under international law, whether the organ exercises legislative, executive, judicial, or any other functions, whatever position it holds in the organization of the state, and whatever its character as an organ of the central government or of a territorial unit of the state. 2.
An organ includes any person or entity which has that status in accordance with the internal law of the state. Organ of the government. Legislative. The people of the government who create the domestic law, the statutory law. This government branch is under subjection to the international order and cannot operate outside the order. If it does so by creating laws that violate the international order, then those laws are void and have no legal effect. Executive. The people of the government that run the government. The Prime Minister, the politicians, the ministers of governmental departments. All these departments and all those people working in those departments are subjected to the universal order under international law. Judicial. The people of the law system. Judges, lawyers, police are all subjected to the international order, and any action taken against their obligations are illegal in scope and nature. It does not matter what country you are living in. These principles of justice create to bring forth the rule of law. The government structure of your country is under obligation to follow the rule of law, and if they do not, then their authority is null and void. Witnesses and testimony from the court to the rule of law. Court judgment. Supreme Court. Christie v. British Columbia, 2005. BCCA 631. The rule of law, a fundamental principle of our Constitution, must mean at least two things. First, that the law is supreme over officials of the government as well as private individuals, and thereby preclusive of the influence of arbitrary power. This is the clear expression of the hierarchy and operation of the rule of law. The rule of law is above and supreme over all government organs and private individuals, meaning they, or we, cannot ignore or disobey the rule of law as expressed under the universal order. The rule of law governs their and our actions and controls their and our behavior. The rule of law cannot be interfered with or controlled by arbitrary power, meaning domestic law cannot override the rule of law, as we saw in Article 27 of the Vienna Convention. DeVito v. Canada, Public Safety and Emergency Preparedness, 2013, SCC 22. Canada's international obligations and relevant principles of international law are also instructive in defining the right. The content of Canada's international human rights obligations is, in my view, an important indicia of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents which Canada has ratified. We clearly see the expression of the hierarchy structure in law from the organ of the state, the court system. The judge declared and expressed the rule of law within the determination that was made. Health Services and Support Facilities Subsector. Bargaining Association v. British Columbia, 2007. SCC 27. 2. SCR 391 confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. Again, we see the hierarchy of law coming forth, but only those who stand in recognition can see it. The ruling or governing force in Canada is not domestic law, but the international order.
The rule of law is about you. The universal order as expressed in international law is built upon and around the recognition of your being, of your life. This is the true and real foundation of the universal order. Under the international order, law is not about preserving authority over being, but it is about recognition and obedience to the inalienable rights of conscious beings. Universal Declaration on Human Rights. Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Now this declaration, which starts to reveal the hierarchy structure of law, makes its first declaration. That declaration being recognition of inalienable rights and the inherent dignity of all conscious beings. This is the opening statement of the declaration, and it shows us the reason for its presence on earth. Well, to recognize something means it already exists. The international order did not create the existence of these rights, but became legally obligated to recognize and ensure these rights. Whereas the peoples of the United Nations have, in the Charter, reaffirmed their faith in fundamental human rights. To reaffirm something indicates that something is already present. Reaffirming does not mean creating. So we see the clear pattern developing that the hierarchy of law that is in operation was not created by the United Nations or country governments, but existed prior and has been recognized and reaffirmed. Thomson Newspapers Limited, v. Canada, Director of Investigation and Research, Restrictive Trade Practices Commission. While individuals as a rule have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, long antecedent to the organization of the state. We can clearly see from the court system that this principle of justice is true, real, and not imaginary. The court declared that our rights as conscious beings existed before any government structure was ever created. Before Canada, United States, Britain, UK, or any other country existed, our rights were operable and are recognized before any created human structure of governance. This is why we find witness in the order that our rights as conscious beings were not being created, but were being reaffirmed and recognized. So what are inalienable rights? Inalienable rights are rights that flow from your being. They flow from the very structure of your existence. They are part of you. Just like your eyes, your legs are part of your biological construction. Your inalienable rights are part of your being, inseparable from your being. Since they are fundamentally part of your being and inseparable from your being, they are absolute and non-derogable. Just like you can't not take your eyes out of your biological being, you cannot separate your inalienable rights from your conscious being. The universal order recognizes this and brings forth this principle of justice under Article 4.2 of the ICCPR, which reads as follows: no derogation from Articles 6, 7, 8, paragraphs 1 and 2, 11, 15, 16, and the 18th of May be made under this provision. This is bringing forth the principle of justice that will control the domestic governments, that will limit their actions against all human beings. These rights that are listed in that article are absolute and inalienable, therefore, by their very description, they can never be regulated away. They can never be limited by domestic law. This is the principle of justice. Under this hierarchy of law, we see the following recognition concerning a particular inalienable right. ICCPR. Article 18.1. Everyone shall have the right to freedom of thought. Conscience. This is part of the structure of your being. You have the right to the freedom of conscience and freedom of thought. This is a universal principle and can never be interfered with. It is non-derogable and absolute. This is the recognition that has been brought forth in the covenant, and therefore it produces a rule of law. The freedom of conscience and thought is part of our inalienable structure and can never be limited or abridged. we see the covenant has recognized this truth. ICCPR Article 5. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation, to a greater extent than is provided for in the present covenant. Since the principle of justice states that no limitation can be placed upon a right brought forth in the covenant, and since we see that Article 18 is absolute and non-derogable, not subjected to limitations, that produces an automatic obligation on domestic government to never create laws that limit, restrict, or remove this recognition. Every governance structure that uses coercion, threats, fear, punishment, deception, implicit consent is violating the principles of justice and the rule of law. Coercion violates your right to choose by forcing submission from you even though your conscience is expressing otherwise. Threats are forcing your conscience to agree and yield to the demand being made out of fear of punishment. This is a direct violation of your freedom of consciousness. Deception is interfering with your consciousness by not allowing you to see the real picture, the true picture. This is interfering with the ability of your consciousness to make a full and enlightened decision. R.V. Wagner, 2015. ONCJ 66. The Rule of Law. I agree with her that the rule of law is, quite apart from the terms of any written constitution, part of the constitutional DNA of this country, and that its precepts must be abided by, and must be applied by judges no matter how strong may be the prevailing winds, or how challenging the social or political environment in which an issue arises. It does not matter what governance, what authoritative structures are complicit in the violations. What matters is that those actions are outside and against the rule of law. Those actions are a violation of your being and are illegal under the hierarchy structure of universal law, which operates on earth. ICCPR Article 16. Everyone shall have the right to recognition everywhere as a person before the law. This provision is not a courtesy, not a policy choice, and not a grant of status. It is an absolute rule of the universal legal order, governing all nations and all organs of the state. To understand it correctly, it must be interpreted through the governing principles you just described. The hierarchy of law, international, domestic, inalienable rights, pre-existing, not created by governments, recognition, acknowledging what already exists, inherent dignity, unconditional value of being, non-derogability, rights that cannot be limited or suspended, the rule of law, state power bound by universal obligation. No government, group, or person may interfere with these rights. ICCPR Art 5. When Article 16 is read inside this framework, its true legal force becomes unmistakable. Article 16 is not about granting status. It is about recognizing the being who already exists. The UDHR opens with recognition of inherent dignity. It reaffirms fundamental rights that precede all governments. It acknowledges rights that exist before any state or legal structure. Article 16 continues this logic. Recognition, equal sign. The international order acknowledging your existence as a juridical being whose rights cannot be denied, overridden, or replaced. It does not create personhood. It recognizes personhood that is already present. This makes Article 16 an existential right, not a political one. Article 16 protects the right to exist before the law as your being, not as a statutory creation. True personhood arises from originated decision capacity, not externally dictated obligations. Inalienable rights flow from being, not from government approval. Article 16 prevents governments from doing the following: forcing a human being into a statutory identity, replacing natural inherent personhood with a legal fiction. Denying recognition to the human being unless they submit to state-constructed statuses, citizen, resident, licensee, corporation, etc. This is why Article 16 is absolute. You cannot be denied recognition as yourself, ever. No registration, no license, no permit, no statutory consent, no government procedure, no administrative regulation may override the universal recognition of your being. Article 16 operates alongside Articles 5 and 4.2, making it non-derogable in practice. ICCPR Article 5 prohibits any government or person from limiting a right beyond what the covenant itself allows. Article 4.2 declares certain rights non-derogable, absolute, untouchable. Article 16 is listed explicitly in Article 4.2, It becomes non-derogable in effect because denying recognition destroys the foundation of all other rights. You cannot exercise Article 6, life, enjoy Article 8, freedom from servitude, claim Article 18, freedom of thought, assert Article 19, expression, claim Article 2 rights, remedy, assert any freedom or liberty at all without being recognized. ***. Recognition is the precondition to every inalienable right in the covenant. Therefore, it is absolute. A right that is required for all other rights cannot be suspended. Article 16 prohibits governments from substituting the natural person with a statutory construct. This is the part domestic governments violate the most. Article 16 forbids forcing people to assume a statutory persona, binding natural persons into legal fictions, requiring licenses or registrations to exist in legal processes, treating individuals as corporate entities, assuming that a human being is the statutory identity assigned to them. This is aligned with Thomson Newspapers, SCC. The individual owes no duty to the state. His rights existed long antecedent to the organization of the state. The state cannot override your identity, repurpose you as a fictitious person, force you into compliance mechanisms, bind you under statutory schemes that violate inalienable rights. Because Article 16 makes clear, you must be recognized as you, not as a creation of statute. Article 16 plus Article 18, freedom of thought, conscience, equal, sign the core of human supremacy over the state. Consciousness is inseparable from being. Inalienable rights flow from the structure of being. Freedom of conscience, Art 18, is absolute and non-derogable. Combine these, recognition of the person, Art 16, plus recognition of consciousness, Art 18, equal sign. Recognition of the being as the highest legal authority under the rule of law. Not the government, not the statutory scheme, not the administrative bodies, not the courts, not the police, the being. That is the universal order. Therefore, Article 16 is the legal acknowledgement that your being is above statutory law. This is the unavoidable conclusion. Article 16 recognizes your inherent juridical identity, your existence, your decision origin, your inalienable nature, your freedom of conscience, your pre-political reality, as superior to any statutory label or domestic law. It is the guardian principle that prevents coercion, threats, forced compliance, deception, artificial consent, compelled recognition as a statutory construct. Because recognition of your being is an absolute requirement of the universal order. No government can override it. No statute can diminish it. No agency can destroy it. No judge can deny it. No law can convert you into a legal fiction against your will. There is no legal justification on earth that allows a government to deny recognition, force a statutory identity, collapse the natural person into a legal fiction, extinguish being, override inherent juridical identity, or treat the natural person as subordinate to statutory constructs.